Thank you for staying tuned to Uganda Broadcasting Corporation Television, where we inspire Uganda. This is a talk show sponsored by the Judicial Service Commission here in Uganda. The Judicial Service Commission likes to be the bridge between the law and the people of Uganda. I'm Jane Kasumba. In studio with me is Ojok Betty, Principal Legal Officer, Education and Public Affairs for the Judicial Service Commission. And every single Monday, we have an official from the Judicial Service Commission to teach our publics about the law. And today we're talking about something rather pertinent. It's land laws. And of course, Betty, before I get into the land laws and land matters, Betty, how was your week?
My week has been good. It has been great. Quite busy, but I'm happy to be here.
Okay, Betty, like I said, is from the Judicial Service Commission. Her role is an important one as the Principal Principal Legal Officer for Education and Public Affairs. Betty's role is to ensure that she's able to disseminate information about the Judicial Service Commission on particular matters. And today she's going to be talking about the land laws. For people who are just joining us, you're tuned into UBC, where we inspire Uganda. My name is Jane Kasumba. Today we're talking about the Judicial Service Commission and what it does. It's an independent commission established by the Constitution of the Republic of Uganda. That's the Constitution of 1995. And one of its major roles as a JSC is to promote public awareness on the law and administration of justice in the country, thus increasing access to justice for everybody. Someone who's watching tonight, Betty, will wonder, where has the JSC been all this while?
Well, thank you very much, Jean. Good evening, viewers. The Judicial Service Commission has actually been here since the 1995 Constitution, because we are created by the 1995 Constitution. So we've been here since. We've done a lot of work for the people of Uganda. We've gone to the community and sensitized them on particular issues of the law. We've gone to radio stations. Yes. We've been to TV stations like this one where I am right now. We've been everywhere in Uganda, interacting with members of the public, listening to their concern, educating them on the laws and administration of justice and so on.
Okay, thank you very much, Betty. So you've heard it from Betty Ojok. She, of course, is a Principal Legal Officer for Education and Public Affairs. Just in continuous to what Betty has been saying, the Judicial Service Commission is located on the ground floor of Farmer's House. That's on Parliamentary Avenue in Kampala. That is on the ground floor, Farmer's House, Parliamentary Avenue, here in Kampala. Perhaps you would like to further discuss some of the matters we discuss on these talk shows. We started off with matters to do with marriage, with succession in various episodes. We also talked about land issues, and of course today we're continuing with land laws that Betty shall discuss. The toll-free number is free for all of you from the hours of 8 a.m. all the way to 5 p.m. every single day. That's 8 a.m. all the way to 5 p.m. every single day. The number is 0800 100 221, 0800 100 221, or 0800 100 222. So that is 0800 100 222. Dial those numbers and talk with someone at the Judicial Service Commission. They will assist you in ensuring that some of these issues that we talk about on these talk shows, especially every single Monday from 9 to 10 on UBC, are further explained to you. Betty, our topic today is on land laws. What do you want people to know in Uganda about land before we get into the legal instruments and everything else that is legal?
Okay, well, thank you very much, Jane. What I would like people to know about land is that land belongs to us, the citizen of Uganda. It is ours. And as per the 1995 Constitution, where land was reverted back to the citizen, but prior to that, land belonged to the government. But after the 1995 Constitution, and the land in Uganda was reverted back to the citizen. So land in Uganda is ours as a right. As a right. All citizens in Uganda have a right to own land and possess land and to utilize it in the best way possible. And that is, the ownership of land is without discrimination. That is, all citizens, whether female or male, we all have rights to land. But surprisingly, you'll notice that in certain areas, particular gender are discriminated against.
Yeah.
They are actually told that they have no right to land, as women have no right to land. But under the law, under the Constitution, under the Land Act, and so many other legal instruments that I will discuss later on, every citizen has a right to land.
Okay, on that note, Betty, we shall get into the matters to do with the law and the legal instruments that govern land laws in this country.
Yes.
When you're talking about legal matters, the first thing that you must always look at are the legal instruments, so that you know where to find your rights, so at the end of the day you know how to proceed. Even as a normal person, perhaps you have an issue in land that you would like your lawyer to oversee or to proceed with. You also need to know what your rights are under the law. So Betty, most importantly, what are the legal instruments that govern land laws or land matters in Uganda?
Well, we have, actually Uganda is blessed because we have so many legal instruments. We have so many laws governing land rights and land ownership in Uganda. And the most important one is the Constitution of the Republic of Uganda, the 1995,
yes.
1995 Constitution. It's actually quite detailed on land rights and land ownership. And it is under the Constitution where we actually find the transfer of land ownership from the government to the citizens, and it is under the Constitution where we find the various land tenure system in Uganda, the different land tenure system that I will talk about later on. So the Constitution is the most important legal instrument, or the laws in Uganda governing land rights and land ownership. And then coming next to that, we have the Land Act. The Land Act also goes a little more into detail on the land tenure system, land rights and land transfer and so on. Then we have what is known as the Registration of Titles Act. This is also very important.
The RTA, yes.
Yes, the RTA is very important because it gives detailed instruction of the process a person has to go through if that person is interested in registering his or her land from, let's say, from a customary tenure to a freehold tenure. If you want to get a land title for your land, your piece of land, which was originally held under customary tenure, the RTA, or the Registration of Titles Act, give you detailed instruction and process of what you have to do to convert that land from customary to freehold. And then we have other legal instruments such as the Compulsory Land Acquisition Act, which is very important because, as I mentioned earlier on, the Constitution bestowed the right to own land on the citizen. But when you look at this law of the Compulsory Land Acquisition Act, it's specific to the acquisition of land by government, and it provides that much as we as the citizen, we have the right to own land, but government has the right to compulsorily take away our land for particular activities,
particular development
and social activities. Like, for instance, if government needs land to construct road, or a health center, or
to put up a pipeline,
those social activities and developmental activities, if government needs the land, then government can compulsorily take land from the citizen. But under the same law of the Compulsory Land Acquisition Act, it goes further into detail to say that before government takes away your land under the Compulsory Land Acquisition Act, government must first compensate you for that piece of land. Now, in the alternative, if government cannot compensate you for that piece of land that it wants to put that social development, government must relocate you to another piece of land, which is more or less equal value as the one it's taking. But then when it's to compensate you, the compensation must be at a fair rate. Must be at a fair rate. And in addition to that,
a fair rate to both.
A fair rate to both.
Both the government and the owner of the land.
Owner of the land. What is normally done under the Act is government valuer comes up with the rate for the property, and then the property owner is actually encouraged to get a private valuer to also come and give a value for that property. Now, if there's a big margin between what the government is offering and what the private valuers come up with, then a negotiation can happen between the government and the property owner, and then they reach an amicable settlement for a cost or for a value of the property where both parties are happy, and then compensation is done.
What about the National Environmental Act?
Well,
it also contributes to land laws, right?
Yes, it does. The National Environmental Act actually stipulates how the environment is supposed to be preserved, how people are supposed to use their land in a way that it does not destroy the environment. For example, I can give an example of how people are not supposed to destroy swamps. We know there are certain activities that previously were being done in the swamp, like cultivation. People destroy the swamp and they plant sweet potatoes or sugar canes and yams, and then in the process it destroys the environment, and we know how important swamps are. So government came up with this legal instrument, the National Environmental Act, to protect our environment and preserve it for the future.
Okay.
And so on.
And of course the Limitation Act is very important when it comes to matters of land.
Exactly, the Limitation Act, time period. It is very, very important in a way that the Limitation Act provides that if there's any legal dispute over a piece of land, the parties involved in the legal dispute must file their complaint to any authority before 12 years elapse. Now, it doesn't specify which particular authority, but you can file your complaint to any. You can take it to the traditional institutions for mediation. You can take it to the police if there are criminal matters involved in the land dispute, or you can file your case to a court of competent jurisdiction. You can file your case to court, either magistrate court. You can also file your cases to the LC court. Currently, they're not in place because the elections haven't taken place. But once they're elected and the courts have been constituted, you can file your cases to the LC court. But what the law provides in the Limitation Act is, if there's a dispute concerning a piece of land, make sure you report the dispute to any authority before the 12 years have elapsed.
Okay. Can you just repeat that, because it's very, very important?
That according to the Limitation Act, if you have a land dispute over any piece of land, make sure you file your complaint with any authority before 12 years have elapsed. You know, some people have actually lost matters before magistrate courts because they file their complaint after the limitation period have expired, after the 12 years. So in such instances, the magistrate can actually just dismiss your matter because you are outside the limitation period. So it is very important that if you know somebody has, let me say, has encroached on your land, maybe encroached on the boundary, or somebody has just grabbed your land or has evicted you wrongfully from your piece of land, make sure you file your complaint with any authority. Take it to the LC, take it to the traditional leaders, take it to the magistrate court or to the high court. Make sure you take your matter before those authorities before 12 years have elapsed. Okay. If you don't do that, then you are likely not to recover your property. However, even if the 12 years have elapsed, but you have genuine reasons that prevented you from filing your matters within the 12 years. Yes. You can still file it after the 12 years. Okay. Yes, you know that, like, for example, there are people out of the country, but they have their property here. So in their absence, somebody has actually taken possession of the property and is using it, and you are out there, you do not know what is happening here. You come back to Uganda maybe like after 20 years. You find somebody has actually taken possession of your house, developed your land, developed it, and so on. Now, this one, you have a genuine reason that prevented you from filing your complaint within the 12 years. So the 12 years limitation period can actually be waived to allow you file your matter after the 12 years. Okay. And of course, customary norms and practices are very important when it comes to issues to do with the law in Uganda. And within our discussion, we will be touching on that a lot. Your take on that as well? Well, it is very important. It's one of the the policies, I could say practices that are adhered to, because when you look at the constitution recognizes customary land tenure system. It recognizes it, and under the constitution, what it provides is that customary land is a piece of land that is governed by the custom of the people. So the law actually allows people to follow the customary norms and practices, as long as the customary norms and practices adhere to the constitution. Like I mentioned earlier, there are certain customs where certain genders are discriminated against. Now, if such custom exists, where let's give an example where it provides that women have no right to property, to land, or women cannot inherit land, then the constitution actually nullifies these customary practices. It provides that if the customary practices is against the constitution, then such customary practice shouldn't be followed. It should be null and void and should not be adhered to.
Okay, our producers throughout the week knew that Betty was coming into our studios, so they did go out into the field and they managed to get a lot of your opinions. And some of these questions, I have to table them to Betty, and some of them are hypothetical questions. A first person, Bernadette was asked us, can I get back my land that my grandparents gave to the church, the school, or to the government?
Okay, well, thank you very much.
Question, huh?
It is a very, very good question, because people who work with the community, who interact with the community a lot, we actually encounter this kind of question a lot when we go to the community. So many young people, surprisingly, most of these questions are raised by the young people. That my grandfather, before I was even born, gave my land to a church, or gave my land to a school or to a local government, and now I want to get it back. It's very surprising how, in fact, in the community, like in the districts where I've been, you find that most of the disputes filed before court are related to this kind of questions. These youngsters wishing to get back the land that was given by their grandparents. Well, to simply answer Bernadette's question, you cannot get back this land that was given by your grandfather long before you were born.
That's a case closed.
That's a case closed. and simply because by the time your grandfather gave the land was theirs, was for your grandfather. And by then they had the right to do with the land as they deemed fit. And again, one of the ways they deemed fit to deal with the land was to donate it to maybe a school or a church. So you cannot claim what was never yours. What you can do is to be happy with the portion that was preserved for you as Bernadette, but you cannot get back what your grandparents gave away. Yes.
Of course, this one comes in from Peter, and he says, my late father did not give me land in his will, and he only left land to his sons. What can I do?
Well,
so I think it seems like maybe this was his son, maybe outside the official marriage or something like that.
Maybe, but to simply answer Peter's concern is that since his late father left a will, he can actually challenge that will in court. He can file his petition in court to challenge that will, and court will assess the evidence brought forward, and if the will.
But he has to prove that he's a son.
He has to prove that he's a son
with a DNA test or something like that.
In any other, he can prove in any other ways. But if Peter's paternity was never challenged by when his father was alive, then probably there is no reason to challenge it now.
Okay.
Yes. If Peter's father, when he was still alive, he took Peter as his son, everybody in the community knew Peter has this gentleman's son, he raised Peter, he educated Peter. There is actually very little reason why to challenge Peter's paternity right now, because the father never challenged it. The gentleman who left the will, he never challenged Peter's paternity. So right now there is no reason to challenge that Peter is not the father, the son,
the biological
son or adopted son or whichever son. It was never challenged before, so there is no reason to challenge it now, because the person who could actually challenge Peter's paternity was the father. But the father is no longer there, he's dead, and he never challenged it during his lifetime. So there is no need to challenge it now.
Okay, this one comes in from Mary. She asks a very pertinent question. She's asking, I have lived with this man, namely her partner, for 40 years, but we are not married. He is now chasing me away. Can I get a share of the land that we've been living on and that I've been tilling?
Well, when you look at our laws,
40 years, by the way.
40 years, yes, that is a very, very, very long time. And it's sad that in 40 years, they did not get time to legalize their union. But when you look at our laws are very particular when it comes to sharing of matrimonial properties. It talks about spouses. You must be a spouse in order to share a matrimonial property in the event of a divorce.
And that is a spouse in all intents and purposes,
exactly,
as per the law.
As per the law, must be somebody who is married to people who are married. Now, married is, you can either be married customarily, which can be either through a quanjula. You know that people actually don't think quanjulas are married. It's a marriage.
We discussed, actually, that was in episode 1 of this series. We discussed the issue of quanjula and whatever. But you register, I mean, you can register quanjula, that customary process.
Yes.
And it becomes legal before the law.
You can register it if you wish, but even without the registration, is still recognized as a marriage, as long as all the terms are followed, like all the things that are requested for have been paid, like, you know, in terms of bride price. If it's paid fully, then you're married. Now, you can either be through marriage through the church, or marriage through the registry of marriage, or marriage through in Islamic religion. But you must be married under the law to actually have right to matrimonial properties. Now, in this particular question, it appears like the people cohabited for 40 years. Now, cohabitation under the law, it doesn't tantamount to a marriage. So sadly enough, this the lady who asked that question will not be entitled to a share of the matrimonial property, because the underlying word is matrimonial properties, and it must be between spouses. Yes.
A very important point there. And this one is also coming in from Susan. It's coming in from Billy, and he says, when I was marrying my wife, she came with a child who is a man now. Is that boy entitled to a share of my land?
Yes, simply. To answer Billy, yes, that boy is entitled to a share of the land if Billy decides to distribute his land among his children. Because legally under the law, Billy accepted this boy, this child, when he was coming with his mother. Billy accepted him, Billy raised him, educated him, instilled in this young man a belief that Billy, was the boy's father. So probably this is the only father this young boy has grown up knowing, calling daddy, daddy. All members of the community actually know that Billy is the father of this man. So if time comes when Billy is sharing the property among his children, he must definitely give a share to this man. Now, if he refuses or he fails to do that, this young man can actually challenge the distribution or challenge the will, or whichever, can actually challenge it
before a court of law.
Yes.
Okay, very quickly before we take the break, Betty, all this that you've been saying really is derived from the principles that govern land ownership in Uganda.
Yes.
What are those principles before we go to the break?
Thank you very much, Jane. We have a number of principles that govern land ownership and land rights in Uganda. Some of them I've already hinted, alluded to in the beginning, but the most important one is that land belongs to the citizen of Uganda. As Ugandans, we have rights to own land, to sell land, to transfer land, to mortgage land, as long as we are doing it according to the law. And then, irrespective of gender, we all have equal rights. Whether women or men, we all have equal rights to own land and any other properties. But another principle is that much as we have rights to own land, government can compulsorily acquire the land from us under the Compulsory Land Acquisition Act, but government has to follow the procedure under the Compulsory Land Acquisition Act, which I've already alluded to, that it must first compensate the landowner, or in the alternative, relocate the landowner to another piece of land, and the compensation must be at a fair value before government compulsorily takes your land.
Okay, another principle about a citizen.
Yeah, another principle about the citizen is that I think I've already mentioned it, that land can be owned by both women and men.
Yeah.
Yes.
Okay. Other principles, of course, that we are very well aware of is that government under compulsory land acquisition can compulsorily take land from citizens, and Betty touched on that, especially for developmental purposes, be it land, be it perhaps the oil pipeline, we discussed all that.
Construction of
health centers, schools, and so on. Yeah. Another principle is before government compulsory takes your land, government must first compensate you fair value for the land to relocate you to a new parcel of land.
Yes.
And you touched on that.
Yes.
The issue that there must be equity must be seen.
Exactly.
Yeah.
Yes.
And of course, lastly, land can be owned by both men and women. Exactly what Betty said.
Yes.
We're going for a quick commercial break. You're tuned into UBC, where we inspire Uganda. This is a special talk show sponsored by the Judicial Service Commission here in Uganda. We're talking about land, laws, and land matters with Betty Ojok. We'll be right back here on UBC, where we inspire Uganda. Thank you for staying tuned to Uganda Broadcasting Corporation Television, where we inspire Uganda. My name is Jane Kasumba. This is a special talk show sponsored by the Judicial Service Commission. Today we're touching on land laws. Every single Monday on this channel between the hours of 9 to 10, you can catch us on this talk show where we try to bridge the people of Uganda and the laws of Uganda. What are your rights before the law? The Judicial Service Commission and its principals, like Betty Ojok here in studio with me, are usually tasked to explain all these matters to you. My guest today is Ojok Betty, Principal Legal Officer, Education and Public Affairs for the Judicial Service Commission. By the way, you know, Betty, a lot of our viewers always say people in Uganda have such long titles. Principal Legal Officer in charge of Education and Public Affairs. What do you do? What is your job?
My job is first and foremost to educate or sensitize a member of the public about the laws, and then administration of justice. That is my role, my job. And then secondly, my second role is to publish literature. Yes, publish different literatures on different areas of the law, and then distribute them out to members of the public. We have the most important publication the Judicial Service Commission has done so far is a book we call the Citizens Handbook on Laws and Administration of Justice.
I've seen it, and yes, I'm very impressed by it.
It's a very, very good book.
Just repeat the title of the book, because everybody who's watching this show really should get this book.
Yes, it's a Citizens Handbook on the Laws and Administration of Justice. It's published by the Judicial Service Commission. Yes, right now we have the 3rd edition, but it's being updated. Yes, so we are about to get the latest edition, which will include a number of amendments that were not there previously.
And why I like the Citizens Handbook is for people who perhaps do not have a legal background. They're able to interpret the law, the English used or the vernacular used, because it's also translated in various languages of our people, is a layman's term.
It is.
And it's not the legal jargon where you see someone speaking a lot of English and you don't understand. So it's a well-written book.
It is.
Just a quick mention of what Betty said. The Judicial Service Commission is here as an independent commission established by the Constitution of the Republic of Uganda, 1995. Its main role is to promote public awareness on on law and administration of justice in the country, thus increasing access to justice. So perhaps if you're watching this talk show, you might want to have these issues like land laws further elaborated to you. You can dial out the Judicial Service Commission numbers, that is 0800 100 221, 0800 100 221, or 0800 100 222, 0800 100 222. All those are toll-free numbers. So Betty, if we can continue, a lot of our viewers have been asking us for you to explain what is the land tenure system, and what are their differences? How many are there, and what are the differences?
Well, thank you very much, Jane. There are actually 4 land tenure systems. Now, land tenure system is the system of land ownership in Uganda, how you own your land. Under what system do you own your land? So under the law, under the Constitution of the Republic of Uganda, under the Land Act, we have 4 land tenure systems in Uganda. Now, the most common land tenure system, and actually the largest, is the customary land tenure system. It is the largest because most areas in Uganda still hold their land under customary land tenure system. Now, customary is simply land that is held, managed, transferred, and so on according to the custom of the people living on that land. Now, I cannot say there's a custom that cuts across. Each culture or each tribe has its own custom under which they manage their customary land. Now, my custom from where I come from in Amuru is completely different from somebody who's holding his land under customary tenure, let me say in Kasese. We have completely different customary tenure, but customs. But what unites the different customary tenure is that our land is held on customary tenureship, and what it means is that the land has no land title. Any land that has no land title is a customary land. Now, a customary land can have a certificate of customary ownership, which is different from a land title. A certificate of customary ownership is a document, a legal document, that actually shows that the customary land that you're having is still, it's yours, and you're holding it on customary tenure. So that is what is called a customary land tenure system. It's a land held under customary norms, and the land has no land title. And the managing, the administration of the land, the transfer of the land, any transaction of the land is governed by the custom of the people. And these customs are different. If I could give an example, like my custom in Amuru, one of the customs is that you cannot sell customary land without getting consent of the whole family.
Okay.
Because the land is not held by individuals. The land is held by the family.
The family.
Yes. So before conducting any transaction on the land, on the customary land, you must get consent of the whole family. For example, if you want to sell the land, then you have to go and gather your family members and request them that that you want to sell the land. If they say no, then you cannot sell the land. And I was actually told in the different districts where I've been to that the customer are a little bit also similar, especially in relation to the sale of customary land. Like I was in the Kasese, and one of the participants during our district sensitization actually informed me that the custom is the same, Betty, because let me give you an example. That he's a pastor, and he wanted to set a church in his customary land, and then when he consulted his clan members, they actually said no. So yes, customary land, actually the customs, some of them are similar.
African customs sometimes are similar.
Yes. Yeah. Now the second land tenure system is the opposite of the first one, the customary tenure. The second one is freehold land tenure. Now freehold is land that is registered and has a land title issued in the name of the landowner or the landowners. It has markstone. In the simple term, like what people have told me in the community, is that they are actually called plots.
Yeah.
If you have a plot which has Maxton and a land title is issued in your name or in your names, because the land title can be issued for a number of people, maybe for two people owning that same piece of land. So as long as you have a land title on your land and the land has Maxton and it is a plot which has Maxton and a land title, then it is, your land is freehold. But I was also informed that there are people who actually have plots which are not land, which have no land title,
Yeah.
but they still call them plots because they are within urban centers. But if your plot has no land, it has a land title, then it's a freehold land. But if it doesn't have a land title, then it is still customary land. Yes. And then the third land tenure system is what we call the leasehold.
Yes.
Yes. The leasehold is in simple terms, is land that you're renting. You are renting it for a fixed period of time and for a particular duration of what? Or for a particular activity that has been agreed upon between the landowner and you who is leasing it or you who is renting it. Now, if I say leasehold, it might sound a little bit complex,
yeah.
but to break it down, the simplest way to define lease is rent. So if you are renting your land from the landowner and you are using it for a particular activity that was agreed upon by you and the landowner, and for a fixed period of time, then your tenureship is leasehold tenure. Now the tricky bit of leasehold is if you are leasing your land and you're using it for that particular activities, once the period you are agreed upon elapse, you are supposed to hand over the land with all development on it to the landowner. Whether you've put a school, a very powerful school, you've put an industry, you've put a factory, you've put a very big, wonderful rental, as long as the period for which you are leasing that land expires and the landowner is not willing to extend the period for you some more years, you're supposed to hand over the lease, the properties and the land back to the landowners.
Okay, and the fourth one, Milo.
The fourth one is Milo. Now, Milo land tenure is specific in that it is specific only to Buganda region. Because I know most of us who went through school, we went through the Buganda agreement and how land was allocated and so on. So it's through the Buganda agreement of 1900 that's when the leasehold tenure came into being. So it is land, it is also registered land, but it has land title, but it is specific only to Buganda region. You cannot be in, maybe let me say Amoro, and you say you have your leasehold, your Milo land in Amoro. It's not there. It is only specific to Buganda region. The land has land title. It's registered land.
Okay. Thank you very much, Betty, for that. A lot of our viewers are asking us, we have a lot of family feuds concerning land. Can Betty kindly elaborate on what laws govern family land in Uganda?
Well, the family land issues to do with family land, we can the law that discusses family land is the Land Act. The Land Act is quite specific on family land, defines what family land is and how to manage family land. And so, for the benefit of our viewers, family land is the land that you are living on with your family. And then family land can also be that land where maybe you're deriving certain economic activities and getting money from the economic activities. Let me say maybe you've constructed rentals on that piece of land and you're getting money from the rental, and it is this money that you're using to take care of your family. Or a family land could be the garden that you're cultivating to get food from food which you're using to feed your family. Or is that piece of land where you're burying the members of your family?
Yes. This
is what is known as family land. Now, even if this land is a freehold land, which is registered in the name of maybe only one person, maybe the husband or the wife, what the law says is, as long as this land is a family land, that person whose land is registered in, whose name is on the title, cannot deal with this land in whichever way he or she wishes without getting consent from the spouse. Let me give you an example. If it's the husband who is the registered owner of this land, but the land is a family land where he is living with his wife. If he wants to mortgage the land, or he wants to sell it, or he wants to lease it to some other person, or to give it to a bank as a security for a loan, he must first get consent from his wife.
Express permission, yes.
Express actually must be written.
Written permission,
from the wife. Previously, before the Land Act was amended, the person actually had to get consent from his wife and his children. But after the Land Act was amended, that section of permission from the children was repealed. So now the husband or the wife must get a written consent from his wife that he wants to either mortgage the property or transfer or sell it or lease it. He must get a written consent from the wife, because I think the law wanted to protect the spouse and the family, because previously people used to dispose of family land. One day you wake up and the court brokers are at your doorway. They want to evict you. You do not know what has happened. You don't know when the land was actually mortgaged. They just hear they will evict you. So to protect family from such kind of event, that provision of the law was put in place. Before you deal with the family land, in whichever way you want to, get a written consent from your spouse. Now the underlying word is a spouse. It must be a spouse. If you're not a spouse, they'll deal away with the what? They'll do away with the written consent.
Our viewers also wanted to know, Betty, what are the most common types of land disputes in Uganda?
Well, there are a number of land disputes. Actually, there are very many land disputes. There are various kinds of land disputes in Uganda. The most common one is boundary encroachment.
Yes.
Now, this is mostly common with the customary land ownership, customary land tenure, simply because there are no permanent marks to show the boundary of customary land tenure. Mostly the boundary markings that are in place are these temporary ones, like ant hills, trees, and swamp. But we know those temporary boundary markings can be destroyed. These days people are cutting down the trees to make charcoal. You might be having some big giant mango trees showing the boundary to your customary land tenure. You wake up in the morning, the trees have been cut it down. So because of this non-permanent boundary marking on customary land tenure, we find that most of the boundary encroachment happen on customary land tenure. Then the other common land disputes that we've seen in the community is when the government compulsorily acquires your land but does not compensate you adequate or compensate you inadequately. That is also common. And then we have people actually, other kind of land dispute is land grabbing, arbitrary land grabbing. Somebody just comes to your land, takes possession of your land and evicts you from your land. And this is also very common with customary land tenure. What we are seeing happening of recent is that somebody comes, identifies a piece of land that is held under customary ownership, and without the knowledge of the landowner, just applies to have this customary land transferred, registered to a freehold land tenure in the name of this person who is grabbing the land. Then after the land is registered, the person starts calling the customary landowner as bona fide occupants.
Yes.
Yet legally, these are actually the customary owners of the land, not bona fide occupants. They are the owners of the land.
This brings me to my next question. What is a lawful and bona fide occupant?
Well, the law on bona fide occupants is actually, first of all, bona fide occupant, a person who is called a bona fide occupant is the person who unlawfully enters somebody's land, occupies this land continuously without any interruption from the landowner for 12 years before the 1995 Constitution. Which means bona fide occupants are the people who've been living on that piece of land from 1995 back, 12 years before the 1995. So if you've been living on that piece of land without any disturbance first of all, you entered the land illegally without the consent of the landowner. Then you settled on the land, and you continuously use that land uninterrupted by the landowner for 12 years before the 1995 Constitution. You are considered a bona fide occupant, and you are protected by the law.
Okay.
Yes.
How are bona fide and lawful occupants, how are they protected before the law?
Well, they are protected in a way that the law provides that you cannot evict them. Like if you have a bona fide occupant on your land, even if this person entered illegally but has lived there for 12 years without any interruption from you, you cannot evict him or her from this piece of land without a court order. Now, a court order, you cannot get it like, you cannot just walk to court and say, I need a court order. It's a process. You first of all file your complaint in the court. Court receives your documents and listen to your witnesses, then it makes a judgment. Now, if you emerge as the victorious member, like you win the case and an eviction order is issued, that is when you can actually go and evict a bona fide occupant or a lawful occupant. Only with a court order. Now, like for a lawful occupant, I don't know whether we touched on it, but a lawful occupant is simply the person who enters your land with your consent and lives on your land. Now, this one, you cannot evict him or her, this lawful occupant, also without a court order. But there's only one reason as to why you can evict a lawful occupant: if the lawful occupant has failed to pay rent. That is the only reason.
And on a parting note, because of the sake of time, we still have to make way for our news this evening. Betty, how can you protect your land rights? A lot of our viewers, really, this was the most important question.
Yes.
How do I protect the land that is mine?
The most important way you can protect your land is to register it.
Yes.
For example, if you have a customary land tenure, please register it. You can process a certificate of customary ownership, or you can process a land title. It is a process, but it's a process that is worth it. It's easy. You apply to the area land committee, then to the district land board, and then the land office, and then you process your land title. Because when you look at the law, the registration of titles Act stipulates that a land title is a conclusive evidence of ownership. So if you have a land title for your land, then it's evidence that the land is yours. So I encourage people who hold their land under customary tenure, please process a land title or a certificate of customary ownership if you still want to continue holding it under customary tenure. And then the second way you can protect your land right is to don't leave your land idle. You know, there are people who have chunks and chunks of land, acres after acres. Me who travel up country a lot to various districts, you stand there and you see miles of land without any garden on it, with no structure, with nothing. And you're like, whose land is it? Now, when you leave your land idle like that, you tempt people who have no land to actually encroach on your land. And because you have such a huge chunk of land, you'll even not know that somebody has encroached on your land. And then thirdly, if you want to buy land, make sure you conduct a thorough search. You know, there are people who actually buy land through, osmosis. Yes. You're in the Kampala and then you call and you say, Elsie, is there any land available? Buy for me. You've not even seen the land. You've not interacted with the land owner.
You've not done your due diligence.
Exactly. You might end up buying air and not land. So if you want to buy land, make sure you conduct due diligence. Search, go to the land registry. If it's a registered land, go to the land office and actually comb that land book to see this land, whose name is it registered in? And if it's registered in the name of Ojok Betty, is it Ojok Betty selling this land? Now, if it's not registered land, if it's customary land, please enter your car or your boda or a bus and go to the village. Physically see the land, that the land has no people living on it or it has no garden. Interact with the local leaders. Ask them whether the person who is selling the land is actually the landowners, because there are people who actually take advantage of the vulnerable members of our communities, like the widows and orphans, and they sell off the land.
On that note, a special thank you to Betty Ojok. She's the Principal Legal Officer for Education and Public Affairs for the Judicial Service Commission. She's done a fantastic job in elaborating on matters to do with land laws here in Uganda. This talk show is proudly sponsored by the Judicial Service Commission. which of course is here to promote public awareness on law and the administration of justice in the country, thus increasing access to justice. You can always watch a talk show like this sponsored by the Judicial Service Commission every single Monday from 9 to 10 so that you as a public of Uganda can get to know the laws of Uganda. On behalf of Betty Ojok and myself, Jane Kasumba, thank you so much for watching UBC, where we inspire Uganda. Have a good evening.